Now we have the judgment here. This is the Chief Justice, Lord Coleridge. The two prisoners, Thomas Dudley and Edwin Stevens, were indicted for the murder of Richard Parker on the high seas on the 25th of July. In the present year, they were tried before my brother Huddleston at Exeter on the 6th of November under the direction of my learned brother. The jury returned a special verdict, a legal effect which has been argued before us and on which we are now to pronounce judgment. The special verdict, as after certain objections by Mr. Collins, to which the Attorney General yielded, it is finally settled before us as follows. From these facts, stated with the cold precision of a special verdict, it appears sufficiently that the prisoners were subject to terrible temptation, to suffering which might break down the bodily power of the strongest man and try the conscience of the best. Other details, yet more harrowing, facts still more loathsome and appalling, were presented to the jury and are to be found recorded. But nevertheless, this is clear, that the prisoner put to death a weak and unoffending boy upon the chance of preserving their own lives by feeding upon his flesh and blood after he was killed, and with certainty of depriving him of any possible chance of survival. The verdict finds in terms that if the men had not fed upon the body of the boy, they would probably not have survived, and that the boy, being in a much weaker condition, was likely to have died before them. They might possibly have been picked up next day by a passing ship. They might possibly not have been picked up at all. In either case, it is obvious that the killing of the boy would have been an unnecessary and profitless act. It is found by the verdict that the boy was incapable of resistance, and in fact made none. And it is not even suggested that his death was due to any violence on his part, attempted against, or even so much as feared by those who killed him. Under those circumstances, the jury say that they are ignorant whether those who killed him were guilty of murder, and have referred it to this court to determine what is the legal consequence which follows from the facts which the jury has found. Certain objections on points of form were taken by Mr. Collins before he came to argue the main points in the case. First, it was contended that the conclusion of the special verdict was not put to them. Let's see. This is just procedural stuff. I don't want to bother addressing. Lack of jurisdiction claimed. Here we go. There remains to be considered the real question in the case, whether killing under the circumstances set forth in the verdict be murder or not murder. The contention that it could be anything else was, to the minds of us all, both new and strange, and we stopped the Attorney General in his negative argument in order that we might hear what could be said in support of a proposition which appeared to us to be at once dangerous, immoral, and opposed to all legal principle and analogy. All, no doubt, that can be said has been urged before us, and we are now to consider and determine what it amounts to. First, it is said that it follows from various definitions of murder in books of authority, which definitions imply, if they do not state, the doctrine that in order to save your own life, you may lawfully take away the life of another, when that other is neither attempting nor threatening yours, nor is guilty of any illegal act whatever towards you or anyone else. Because, of course, if the other was guilty of some unlawful act, we'd be talking about the justifications of self-defense or defense of others or something else. But if these definitions be looked at, they will not be found to sustain this contention. The earliest point of date is the passage cited to us from Bracton, who lived in the reign of Henry III. It was at one time the fashion to discredit Bracton, as one of the lawyers tells us, because he was supposed to mingle too much of the canonist and civilian with the common lawyer. There is now no such feeling, but the passage upon homicide on which reliance is placed is a remarkable example of the kind of writing which may explain it. Sin and crime are spoken of as apparently equally illegal, and the crime of murder, it is expressly declared, may be committed lingua vel factor, so that a man like Hero, done to death by slanderous tongues, would, it seems, be, in the opinion of Bracton, be a person in respect of whom might be grounded a legal indictment for murder. But in the very passage as to the necessity on which reliance has been placed, it is clear that Bracton is speaking of necessity in the ordinary sense, the repelling by violence, violence justified so far as it was necessary for the object, any illegal violence used towards oneself. So really, he's talking about self-defense. If, says Bracton, the necessity be evitab, evitabilis et evidera. Okay, I'm not going to read all the Latin here, folks. Sorry, I don't know Latin, except for the little cliche stuff we learn as lawyers, the little phrases. Words which show clearly that he is thinking of physical danger from which escape may be possible, and that the inevitable necessity of which he speaks, justifying homicide, is a necessity of the same nature. Let's see how much of this flowery language they put in here that's not actually applicable. Again, now they're distinguishing between the doctrine of necessity and self-defense here. It is, if possible, yet clear that the doctrine contended for, necessity, receives no support from the great authority of Lord Hale. It is plain that in his view, the necessity which justified homicide is that only which has always been and is now considered a justification. Quote, in all these cases of homicide by necessity, he says, as in pursuit of a felon, in killing him that assaults to rob, or comes to burn or break a home, or the like, which are in themselves no felony. Again, he says that the necessity which justifies homicide is of two kinds. The necessity which is of a private nature, the necessity which, that's one. Two, the necessity which relates to the public justice and safety. The former is that necessity which obliges a man to his own defense and safeguard. And this takes in these inquiries. Ask these questions. What may be done for the safeguard of a man's own life? And then follow three other heads not necessary to pursue. Then Lord Hale proceeds. As touching the first of these, homicide in defense of a man's own life, which is usually styled as se defende, self-defense. It is not possible to use words more clear to show that Lord Hale regarded the private necessity which justified, and alone justified, the taking the life of another for the safeguard of one's own to be what is commonly called self-defense. Let's see. But if this could be even doubtful upon Lord Hale's words, Lord Hale himself has made it clear. For in the chapter in which he deals with the exemption created by compulsion or necessity, he thus expresses himself. Quote, if a man be desperately assaulted and in peril of death and cannot otherwise escape, unless to satisfy his assailant's fury, he will kill an innocent person then present, the fear and actual force will not acquit him of the crimes and punishment of murder, if he committed the fact. For he ought rather to die himself than kill an innocent. But if he cannot otherwise save his own life, for the law permits him in his own defense to kill the assailant. For by the violence of the assault and the offense committed upon him by the assailant himself, the law of nature and necessity hath made him his own protector. So what they're talking about here is they're distinguishing not just self-defense from the doctrine of necessity, but self-defense from the defense of coercion. So coercion is a legal defense. You committed an unlawful act because you were compelled by a threat made to you by another person. So someone holds a gun to your head and says, steal that car. And you steal the car because you don't want to get shot dead. Normally, of course, the stealing of the car would be an unlawful act, a criminal act for which there'd be criminal liability. But if it was committed under coercion or duress, sometimes is the phrase, the legal defense of coercion or the legal defense of duress can excuse the criminal liability. But the legal doctrines of coercion and duress can never excuse liability for you killing another person. Because there's no, so someone holds a gun to your head and says, stab that person dead or I'll shoot you through the head. And you stab the person dead, you are doing it under circumstances of coercion and duress, but coercion and duress will not excuse a killing, because from a public policy perspective, you killing that other person is not a greater harm than you having been killed by the person putting you under duress. It's closely related to this lesser harms doctrine, to the doctrine of necessity. I see Legal Vices is in the chat. Legal, if you don't have this document and you'd like it, I'll email it to you. It was a little tricky for me to find, but I'm happy to share it. And Legal Vices is an expert in admiralty law, so he'll have a lot more admiralty detail. I know nothing about admiralty law. Let's see. What else? Yeah, I don't want to read every word of this. We are on page 12 now. Okay, this looks interesting. In East's Pleas of the Crown, another authoritative text, the whole chapter on homicide by necessity is taken up with an elaborate discussion of the limits within which necessity of self-defense is a justification of or excuse for homicide. There's a short section at the end, very generally and very doubtfully expressed, in which the only instance discussed is the well-known one of two shipwrecked men on a plank, able to sustain only one of them, and the conclusion is left by Sir Edward East entirely undetermined. Another example, another treatise, the whole chapter on justifiable homicide assumes that the only justifiable homicide of a private nature is the defense against force of a man's person, house, or goods. We find again that the case of the two shipwrecked men and the single plank, with the significant expression from a careful writer, quote, it is said, in italics, to be justifiable, but clearly very ambiguous support, if any. Another authority clearly considers necessity and self-defense to be convertible terms, though he prints without comment Lord Bacon's instance of the two men on one plank as a quotation from Lord Bacon, adding nothing whatever to it of his own. So not necessarily supporting that position. That the two men on the plank that can only sustain one, it would be lawful for one to shove the other off the plank to his death.